Judiciary and Public Safety Committee will come to order. Today is Monday, March 3rd, 2025, and we do have a quorum present. Members, we have a lot of bills to go through today. Some of these are going to be laid over for possible inclusion because we are, they have fiscal notes that are pending. Others we will be taking some action on because other committees have requested them. So we will proceed right now with Senator Lang's bill, Senate File 281. Senator Lang, welcome to the Judiciary.
Good morning, Mr. Chair, and I think a couple of thank yous are due to begin with. Thank you to yourself and the committee for hearing the bill this morning, and thank you to Senator May Quaid for a bill that we've been working on for a couple of years. I think we're at a point now where the bill is rather short, Mr. Chair, but it's precise in the way it's actioned. So, Mr. Chair, members, I wish I wasn't here this morning. I wish I wasn't here because I'm here for a reason that, to be honest, hits pretty close to home. This bill reflects work after a local 16-year-old individual. And maybe I should preface this, Mr. Chair, by saying that I think the problem lies within the fact that as adults, or maybe Gen Y, Gen Z, as we go forward, how do we relate to what happens on the internet? How do we relate to what happens in our kids' hands and their phone? How do we, as adults now, and somewhat removed from the fact that how involved our children are, both on the internet and in their interaction with people throughout the United States or internationally, how do we protect them? So this bill addresses that in a couple of ways. The individual I'm talking about was a 16-year-old boy that had been sending messages online. And those messages turned into, we call it coercion within the bill. Mr. Chair, it's blackmail is what it is. It's perpetrated by people online, and it, in this case, resulted in that individual taking his life. A young life that really saw no way forward. So that's why I'm here. So, Mr. Chair, to talk about the bill in short, it provides an avenue for the state to prosecute these individuals. It provides a penalty. And truthfully, Mr. Chair, the problems that you most likely will talk about today in committee is how do we find these people? How do we prosecute them? That is the challenge that still remains after this bill. So how do we protect our kids? The last paragraph in the bill, that's section 2, the public awareness campaign. We need to let our children know that we're there for them. Whatever situation they find themselves in, whatever situation, how bad it may seem to them, there is a remedy for it. There is statute from the state of Minnesota. There is individuals there are help you, school counselors, anybody, parents, just let these kids know that we are there for them. And that may, Mr. Chair, be almost the most important part of this bill, is the fact that we're trying to let these kids know that we can help them. There is light at the end of the tunnel. So with that, Mr. Chair, I have a testifier that is online. I wish she could have been here today, and I'm sure she wishes the same. And if I could turn it over to her at this time, Jamie, if you're there, please tell us your story.
Thank you, Senator Lang. Jamie Bremseth is online. We're pleased that you are able to join us here today. If you would go ahead and just state your full name so we have it for our record, and then we'd like to hear what you have to say.
Thank you, Mr. Chair, and thank you, Senator Lang. My name is Jamie Bremseth.
We can hear you.
Okay, thank you. As Senator Lang said, I live in Olivia, Minnesota. I am married with 3 kids, and my oldest son, Carter, he died when he was 16 years old. And my 2 younger kids are now 16 and 12. I'm a mental health professional, so I work every day with kids. They are my target audience. I work with them in 2 school districts, and I work with kids ages 4 to 18. I also work in a mental health crisis center, so I work with people who are experiencing suicide ideation almost on a daily basis. On December 5th, my oldest son, Carter, December 5th, 2021, so 3 years ago, my oldest son, Carter, died from suicide. After being unable to reach him at home and needing to talk to him, I ran home from my daughter's dance recital that night and found him in his bedroom lying on the floor. He had shot himself with his hunting rifle. To say I was in shock is an understatement. Carter did not experience any of the warning signs that as a professional I should have or would have noticed of suicide. He was very happy, almost annoyingly happy to his parents at times. Pretty typical 16-year-old, did not experience depression or any clinical mental health disorders. He loved golf and he loved his friends and he loved his family, and he was getting pretty excited about what his future could hold. The police conducted their investigation, and about 10 days after he died, we learned he had been the victim of sextortion. On 12/4, he was contacted by somebody on Instagram that was posing as a 16-year-old girl. The evening of 12/4 into 12/5, so Saturday into Sunday, their conversation was pretty typical of what you would expect from teenagers. At about 4 p.m. on Sunday, 12/5, his perpetrator first asked for nudes. Carter originally said no. It was something he wasn't comfortable with, and he told this person that. But this girl, or whomever she was, convinced him. She was really good at what she did, and throughout the whole conversation, you could see that she was using grooming techniques just for this moment of when she asked for these pictures. We learned that it took less than an hour from the time that she asked him for the pictures to when I found Carter dead on his bedroom floor. She shamed him. She pulled up pictures of his screenshots of his friends' profiles and threatened to send his pictures to these people. He begged her not to multiple times, and he even followed her demands of sending money. When she started asking for more money, and when he did learn that this person sent his pictures to his friends, was when he first stated that he was going to kill himself. I read the conversation between him and this perpetrator once I received his phone back from police. It started on Instagram. Like I said, it started relatively average or typical. But later on Sunday, she moved the conversation to Snapchat, which is a pretty typical move for these perpetrators. Reading his conversation, I saw the fear, the panic, the shame that he was experiencing. I could hear it in his texting. I could hear it in what he was asking her to do. He begged her multiple times to stop what she was doing. But it didn't matter. He felt like he didn't have a way out. He felt like there was no other choice, even though I had talked to him multiple times about this as a parent and as a mental health professional. He knew what to do in this situation. He knew that he could ask me for help no matter what happened, but it didn't matter. In that moment, he was scared. And she had gotten him to the point where he felt like there was nothing else he could do. In the last 3 years, I have learned a lot about sextortion and met multiple parents who have lost their sons to suicide because of sextortion. I believe the number of deaths is up to 42 in our country. Brandon Guffey, a state representative from South Carolina, is included in this group of parents. Our children are being targeted, tortured, and shamed online. I know of at least one other parent in Minnesota whose son has also died from suicide because of sextortion. She is choosing to stay anonymous, and so isn't with me with this today. As a mental health professional, I hear often about kids getting bullied online, usually by their peers. I had multiple conversations with Carter about this, educating him about what sending nudes can do, the criminal charges that can be, held against him, the risks to it, the risks of bullying and coercion on social media. And in fact, he had only gotten social media 6 months before he died because I did not want him to have it because I was afraid of something like this happening. And it still happened to my kid. Despite all of the safeguards I thought I had in place, all of the education that I offered him, it still happened to him. We live in a very greedy world, and that combined with somehow kids and even adults feeling like it's safer to interact with people online because we don't think they're real people or because we feel like they can't really hurt us or for whatever the reason. It's a very scary combination. People who knowingly commit these crimes against kids, and in fact target kids specifically because they know that they are more vulnerable and more at risk, need to be held accountable. My son's life mattered. We are currently working with the Minnesota BCA, who is investigating his case because his perpetrators are from Nigeria. But we know that the same stuff happens in Minnesota every day. They do not all end in suicide, thankfully, but kids deserve to feel safe. They deserve to not be at risk of extortion, being coerced, or otherwise blackmailed. We as parents do need to do our part in educating our kids in order to keep them safe. It's our responsibility. And I took that very seriously, but it still was not enough. But I really hope as legislators, you will also do your part in holding people who commit these crimes accountable against our kids. Thank you.
Ms. Bremsa, thank you for appearing today and for sharing your story with us on behalf of the committee. We're so sorry for your loss. We appreciate your working with Senator Lang to try to address this legislatively as well.
Thank you.
Senator Lang, do you have any other testifiers?
I do not, Mr. Chair.
All right. Do any members of the committee have any questions, either for Ms. Bremseth or for Senator Lang? I'll just point out the bill language in staff summary has been handed out to the members of the committee. The section of statute that is proposed to be amended is 609.27, which is the coercion statute, but in particular, if you look at subdivision 1, paragraph 6, it creates a cross-reference to 617.261, a non-consensual dissemination of private sexual images. And that's the link here, so that if there were to be any follow-up great bodily harm or death as a result, it creates a more serious penalty in the penalty provision under the coercion statute. There is understand a fiscal note that is going to be requested. Any of these penalty increases that has the potential for a bed impact in the Department of Corrections, the state prison system. So we need to get that analysis before we can do anything else with the bill at this point. Also, the public awareness campaign doesn't have a specific appropriation in there. So we would need to have a fiscal analysis of that, and part of that center language should probably work with you to determine if there's a dollar amount that you'd like to have considered for that. All of our budget bills, of course, are going to have to factor in whatever our budget situation is. We'll learn more about that Thursday, I understand, as well, with the release of the budget forecast for the rest of the session. With that, members, not seeing any further discussion on this, we're going to lay Senate File 281 on the table.
Thank you, Mr. Chair and members.
Thank you, Senator Lang. She stepped off. Well, that's good. She was up first. Let's do that. So, members, we're now going to start, go back to the beginning of the agenda. Senator Gustafson, Senate File 190. Senator Gustafson, if you'd like to come forward. And if you have a testifier with you, Aaron Frederickson, you can come forward as well. This is another bill that's going to be laid over for further information to be gathered and possible inclusion in a budget bill. So Senator Gustafson, if you would, members, you're getting the copy of the bill and council's description of the bill as well. Senator Gustafson, if you would summarize the specific provisions of the bill, and then we'll hear from your testifier as well, who I also believe has a supplemental document that's been distributed to the committee. So, Senator Gustafson, go ahead.
Thank you, Chair Latz and committee members. Sports officials ensure fairness, safety, and integrity in our youth athletic programs, yet they are increasingly facing threats and violence just for doing their jobs. No referee or umpire should fear their safety at a youth game. This bill sends a clear message. Minnesota values respect in sports, and assaulting an official will have serious consequences. We must protect those who make our games possible and set a better example for the next generation of athletes. And also be mindful that the most prevalent amongst the audience during an assault are children, which is why the need for an uptick in penalties. I'm also thankful to have our soccer referee and constituent, Aaron Frederickson, here to testify today. He'll be able to speak in his own personal experience about why these protections are necessary to put in place. Thank you.
And we have a testifier here who wishes to testify. Could you state your name, please, and begin your testimony?
Sure. My name is Aaron Frederickson, Aaron Frederickson. Mr. Chairman, Senator Gustafson, members of the committee, thank you for taking time to provide a hearing for Senate File 190. I've been involved in youth soccer since I was a child. More recently, in 2018, I became an official, and since that time, I've worked over 3,000 sanctioned soccer matches, and I've seen the good, the bad, and the ugly of youth sports just in that short time frame. This past fall, I was physically assaulted twice by coaches at youth soccer matches. In both instances, I did what I was supposed to do, reported the incident, and also filed complaints with the corresponding police departments. And sadly, nothing happened. You might be shocked as a lawmaker. However, I wasn't surprised. I've seen this happen countless times to other youth soccer officials, and nothing happens. Quite frankly, it's a joke. This brings me to the question that you probably have of why should you support something like this? I think bullet point number one is Senator Gustafson clearly stated, this is stuff that kids are seeing. Kids see it, it becomes normalized. And it's funny, hey, let's go ahead and do it ourselves, right? If the coaches get away with it, it trickles down to the parents. There is a toxic environment out there. In the average evening during the summer, I run 10 to 15 miles on a 2-match set. Then I got to worry about running that gauntlet to go get my car or parking someplace so I can kind of make that exit. And there's countless times that I have to do that. All because I probably jeopardized some kid's college scholarship, believe it or not. There's also a lot of money in youth soccer. There's a lot of directors of coaching in our state that make over $100,000 a year. Me, I'm out there chasing an extra $50, $60, all because, hey, it's fun to go ahead and pick on the referee, and it's about the kids, right? In interest of time, I've provided supplemental material on the 2 incidents that happened to me. I'd love to repeat what was said to me, but it probably would not be acceptable for a proceeding like this. So here's your chance. It's about the kids, right? But there's a lot of people like me, adults, who are getting targeted. And if a coach feels safe to go ahead and target an adult like me, one can only imagine what they're doing to a 13-year-old, a 14-year-old, whatever. And then, hey, our game got canceled because we didn't have any referees. Thank you very much for your time.
Thank you very much, Mr. Frederickson. Any questions or comments from members of the committee? Senator Limmer.
Thank you, Madam Chair. This bill reminds me of a different statute, one where bodily fluid or feces would be thrown at either a police officer or a correction officer. And does the penalty in this bill reflect the same penalty in that regard for the example that I mentioned?
Mr. Backus, can you take that one?
Madam Chair and members, yeah, this is the 4th-degree assault crime, and this provision simply enhances what would basically otherwise most likely be a misdemeanor to a gross misdemeanor. I believe I'd have to look. I think for peace officers, it's a gross misdemeanor for I think it's just a low-level assault. Anything with demonstrable bodily harm or throwing bodily fluids, I think is a 3-year felony. So I think there's a lot of variety in that law in terms of what the penalties are, depending on who the victim is.
Senator Limmer?
Madam Chair, I know that my memory was that it was a more severe penalty, but it also involves a person at a heightened level of authority, a police officer, as opposed to a coach. The victim in this case is a victim nevertheless, but a police officer, usually in a confrontation with someone perhaps breaking the law, it has a little different intensity in the event. I just wanted to test the proportionality on it. And at this point, I don't have any further things to say about it.
Senator Gustafson, did you want to respond?
Oh, thank you, Madam Chair. Thank you, Senator Limmer. Just a minor correction, that wouldn't be for coaches, it's for the referees or umpires. And so you're right, not at the same level as a police officer, but still that level of authority that is really all that there is at the games. And again, I just want to emphasize, this is something that if you ask anybody in your communities who is involved in youth sports, I had a completely separate meeting this morning, and they had just seen that this was on the schedule for today, and he said, I got attacked twice last year. That was for a football coach. The person who testified 2 years ago was a baseball coach. He had been assaulted more than twice and had his life threatened. And these are in all parts of the state. So it is a concern, and I think if you can listen to my testifier, you'll understand that it is one of those things that's just getting out of hand, and something has to be done. But I do understand the difference that you're trying to make there, so I appreciate that.
Any other questions or comments from members of the, Senator Westrom?
Madam Chair, to the testifier, what is typically provoking the attack or the follow-up or the hostile conduct? I'm guessing, is it calls in the game, or is it other things that what's generally provoking those things from your perspective?
Senator Gustafson?
Thank you, Madam Chair. I'm going to let my testifier answer that.
Mr. Frederickson?
Madam Chair, Senator Westrom, what provokes these people? I have absolutely no idea, other than maybe there's some mental health issues going on. In one instance, this was a coach that was upset about an incident that happened almost a year to the date before, and he needed to correct the wrong to it. In the second instance, it was a coach that was upset about, he had a misunderstanding of the rules or the laws of the game, as we call them in soccer. And he even stated in an email to the league official that he had never been so upset and quote-unquote lost his mind, I think. Even putting it in more recent context, yesterday I was working a futsal match, street soccer at Minnesota Futsal League at the YWCA on Lake Drive, and there was a parent that needed to be dismissed. Thankfully, my signer was there and was able to handle the situation, but this was a U10, 10-year-olds here, and he got so upset about a call that no one else was upset about. Even the coach from this boy's team was wondering what his problem was, and I shared it was he thought that I missed a call when his team was up by 6 goals with 2 minutes left in the game. So this just shows you kind of, I mean, honestly, the insanity of it. And honestly, where I'm at, I don't know if it's worth it. I honestly don't know if it's worth it. And what happens is I don't show up. I stop officiating. I mean, I do over 500 matches a year. These kids aren't going to have officials because some of those 500 matches are me getting a call saying, hey, I know that you worked a doubleheader, but we need you to work a third match after that. Sorry, I'm 50 years old. It's getting a little hard. So I hope that provides some insight.
Senator Westrom?
And it does, and Mr. Chair, or Madam Chair, and I guess I'm just trying to add, figure out some perspective. Everything from, is it call driven, but it's not just calls, well, I mean, not in the immediate game. That's typically, I guess, where I was thinking you were going, but when it's coaches and it's from games months or years, a year prior, it gets to be kind of a, how do we deal with this? I know some have talked more and more about with the video instant replay, you know, is there a way to bring that into the last 2 minutes of games to give everybody a more fair feeling? If something got missed or something got called wrong, they can change it. Would that help moderate some of this? But I don't know. What do you think about that? While you're here, I just thought I'd ask you the question.
Mr. Frederickson?
Madam Chair, Senator Westrom, I don't necessarily know if the leagues want to pay for VAR or something like that. And in all honesty, I think that's part of it because, you know, some parent standing 60 yards away had a way better angle and a way better view of me standing 10 feet away. And thank you very much for no jokes about me wearing glasses while testifying, but no, I mean, it's honestly insane. VAR or instant replay, I think, is part of the issue, but 10-year-olds, really. I screwed up some kid's chance of getting a college scholarship yesterday because I missed a call that probably 99 other people didn't see and weren't concerned about. Maybe we can add a mental health component to this bill too,
Madam Chair.
Senator Westrom?
So, Madam Chair, and just in a little levity, of course, glasses are better than me reffing, but 2 years ago, one of my most popular hits on my Facebook was when they were so desperate for refs, I was reffing my girls' volleyball game as they were having a pep fest to go to state, and so the team elected to have me come in and ref, and that was a pretty popular video. So it could be worse.
Well, and Senator Westrom, I know that you, like me, you're
Mr.
a William
Frederickson.
Mitchell College of Law grad, so I would never question, any of your calls at all, so.
Okay, Senator Kroon?
Thank you, Madam Chair, and this is more of a comment, but maybe a question as well. I mean, obviously, the criminal code is one thing, and I think there's some merit to enhancing the penalties here as proposed in the bill. But, I've been a youth sports coach, or used to be, for several years, and I did not personally witness any behavior like this from other coaches. And I think one of the reasons was that the association that we were a part of had a zero tolerance policy, and if one of the coaches were to ever assault a referee, you would never be a coach in that association ever again. So maybe the question is I don't know what the soccer world, and I coach primarily hockey and football and some other things, but what are the associations or the leagues or the clubs or whatever doing from a policy standpoint to make sure that this is very clearly unacceptable behavior from their standpoint? Is there anything that's going on that front?
Senator Gustafson or Mr. Frederickson?
Madam Chair, Senator, what's going on? Nothing. Nothing's going on. One of my assaults that I outlined was Minnesota State High School Sports League. Do you know how many calls from the league I got about that assault? 0. Do you know how many emails or text messages I got from the league? 0. The customer, Senator, is the coach. You always need to please the customer because the customer is always right. And that's exactly what's happening too, even in league play. There's a lot of money and you don't want to upset the customer. I know I'm here specifically on this bill, but I do think that there's room where the high school league can improve the safety of its officials. United States Soccer Federation had a new policy regarding referee abuse that went in effect on March 1st of this year. It's a complete joke. And the reason why it's a complete joke is if you read through the United States Soccer Federation bylaws, The mechanism is puzzling, mind-numbing, impenetrable, and at the end of the day, it gives 10 different member organizations the option to do something, and nothing happens because the customer is always right.
All right, Senator Kern, then we're going to wrap this up and move on to our next bills.
Thank you, Madam Chair. I appreciate that. And yeah, I was coaching at the lower levels, primarily under USA Hockey and Minnesota Hockey. But maybe if these regulatory or these associations are not doing anything, particularly the State High School League, which is extremely disappointing to learn about that, I think we may have to deal with this in the criminal code, and out of necessity, it sounds like we're going to have to do that. But I think a bigger issue that we all here have to grapple with is that this body needs to have more oversight over the State High School League. And that's something that we're going to have to work on, because this wouldn't be necessary if they would take this kind of thing seriously and make sure that they had a zero tolerance policy towards assaulting referees. And it's very disappointing to learn that they're not. So that's just my commentary on that. But having said that, I think this is a good bill. Thanks, Madam Chair.
Thank you, Senator Kroon. Thank you, Senator Gustafson and Mr. Frederickson. Senate File 190 is laid over. And Senator Gustafson, you can stay right where you are and tell us about Senate File 662.
Thank you, Madam Chair. The next bill is on a very different topic. Consent is not optional. When someone agrees to protected sex, that agreement does not include the removal of a condom without their knowledge. The consensual removal of a condom, known as stealthing, is a violation of trust and bodily autonomy, one that can have serious physical and emotional consequences. Right now, Minnesota law does not provide a clear path for survivors to seek justice. The bill changes that by creating a civil cause of action, ensuring that victims can hold perpetrators accountable. No one should have their consent disregarded, and this legislation makes it clear that stealthing is not just unethical, it's a violation of consequences. A lot of times as we put the work into this bill, the question kept coming up, is this really something that is happening? And the answer is yes. In fact, studies show that up to 43% of women have experienced this, although it's difficult for us to think about. If the number is high, it's likely that you know somebody who is affected by this form of sexual violence. There is no doubt it's an uncomfortable topic to discuss, not one that I have set out to have with my legislative colleagues, but therefore, does not mean that it isn't important. I urge each of you to consider the gravity of this issue and to support its vital legislation. I'd also like to remind everybody that it was 3 years ago that our colleague Senator Dietzich carried this bill. She writes, "It is inexcusable that there are no legal ramifications for non-consensual removing a condom during sexual intercourse. Consensual sex is only consensual if both parties give enthusiastic consent, and that it includes before and during. Stealthing is sexual assault, and it can lead to unwanted pregnancies. Victims of this cruel and reckless assault should be empowered to pursue civil action against the perpetrator. This common sense proposal is needed by our legislation today." Thank you so much. And I believe we have an amendment, Madam Chair.
And that is the A1, which has been passed out, and this is an author's amendment. Senator Gustafson, is that correct?
Yes, Madam Chair.
All right. Senator Clark moves adoption of the A1 author's amendment. All those in favor say aye. Aye. All those opposed? The amendment is adopted. And you have a couple of testifiers, is that correct?
I do. Thank you, Madam Chair.
We are pulling them up. It looks like they're on Zoom.
Hi, can you hear and see me?
Yes, we can see you. Can you state your name, please, and begin your testimony?
Yes, Emma Schwartz, SCHWARTZ. Thank you, Chairman Latz and committee members. The night of my assault, I knew something horrific had happened to me. I cried myself to sleep feeling devastated, scared, confused, violated, and deeply disrespected. Alone in the dark, I Googled, "Is it assault if my boyfriend removed his condom without my knowledge?" Yes. Yes, it is. I will never forget the searing pang of sadness I felt upon learning that such a heinous act, non-consensual condom removal, had been awarded such a cheeky nickname, stealthing. A dangerous form of sexual violence, non-consensual condom removal robs victims of bodily autonomy while also posing serious risks, including the potential for unintended pregnancy, sexually transmitted infections, and severe psychological consequences. Despite a victimization rate indicated to be as high as 43% for women and 19% for men who have sex with men, laws have grossly failed to keep pace with the widespread recognition that stealthing is a serious and prevalent form of sexual assault, and remain largely void of language specifically addressing this behavior. The Department of Justice defines sexual assault as any non-consensual act prescribed by federal, state, or tribal law, and U.S. Code 920 identifies sexual assault as any person who commits a sexual act upon another person without the consent of the other person. Yet, the nonspecific verbiage of consent, gender-based violence, and civil rights statutes at the state level is often confusing, thus deterring stealthing victims from pursuing justice. It is time to change that. The 10% of our population relying on condoms deserves to have protections in place and the right to seek justice when the scope of consent they supplied was violated. Being a victim of stealthing wholly upended my mental health to the point where I even abandoned in-person schooling for a semester after being diagnosed with PTSD and developing severe anxiety and insomnia. I've worked consistently and diligently in therapy over the 3 years since my assault to regain control of my mental health. But make no mistake, I am forever changed. The people who love and surround me are forever changed. Yet, the laws have stayed the same. As a result, I founded a national organization dedicated to fighting for anti-stealthing laws. I do not want to wake up another day without protections in place for victims such as myself. And I do not want to receive another call from a victim asking what they can do to seek justice and have no clear-cut reply. It's time. As lawmakers, you have the unique power to make Minnesota safer and the ability to protect your constituents from the dangers of non-consensual condom removal. Please support SF 662. Thank you.
Thank you for your testimony, Ms. Schwartz. Our next testifier, could you please, we're getting you, hold on. All right, could you please state your name and for the record and then begin your testimony?
Yes, hello. My name is Jenna Monday. Thank you, Chair and committee members, for letting me speak in support of SF 662. I'm a senior at the University of Minnesota, and I am the chair of the Undergraduate Student Government Specialized Committee on Public Health and Sexual Assault Prevention. My committee works to make the university safer by spreading awareness and education about sexual assault prevention, as well as ensuring accessibility of resources for victims and supporting them as they seek justice. In my role, I feel responsible for taking every opportunity to educate about, prevent, and advocate against sexual misconduct in any form. This includes stealthing. Stealthing is the non-consensual removal of a condom during intercourse. Though not every college student chooses to use condoms, they are a widely spread and accessible form of contraceptive at the University of Minnesota, as many people, offices, and buildings offer them for free. Student studies indicate that 50% of college students rely on condoms as their primary form of contraception. There are over 30,000 undergraduate students at my university alone. The reason condoms are so widely distributed at the university is to promote safe sex that protects both parties. Both parties consent to having intercourse under the conditions and understanding that a condom is there to protect them. However, when the condom is removed non-consensually, that intentionally undermines the agreement between both parties that they made in order to be safe and prevent unwanted pregnancies and STIs, and puts the non-consenting party in a vulnerable position. Victims of stealthing have had their trust broken and their bodies violated, an act that is not only unacceptable, but a form of sexual assault that needs to be recognized formally by Minnesota. Other states like California, Washington, Vermont, and Maine, along with countries like Australia, the UK, and Canada, and many more have already recognized it. As lawmakers, you hold the power to make Minnesota safer, not only for all Minnesotans, but in particular the vulnerable college-age demographic that I am surrounded by and work so hard to protect in my daily role. Please make Minnesota a safer state and support Senate File 662. Thank you.
Thank you for your testimony, Ms. Monday. And finally, we have Carrie Schwartz. Ms. Schwartz, if you could identify yourself, please, for the record and begin your testimony. Thank you.
I am Carrie Schwartz, SCHWARTZ, Thank you, Chairman Lutz and committee members. I'm very grateful for the opportunity to be here today. Again, my name is Carrie Schwartz, and like most sexual assault advocates, I did not fall into this line of work by accident. I will never forget the moment when 3 years ago, my eldest daughter, Emma, who you just heard from moments ago, came to me, sobbing and distraught with tears covering her face. She told me her then boyfriend had removed his condom without her knowledge or consent. She asked me, "It's assault, right? It's rape, right?" I'm embarrassed to admit that at that time, I had never heard of stealthing. I even had to Google it. Emma touched on her battle with becoming a survivor of this very specific type of sexual assault that is widely occurring in our communities, yet seldom discussed. I can assure you the time allotted for our testimonies will never fully allow us to illustrate the magnitude it took on her well-being, nor the extraordinary measures required for her to regain her mental health. I am so proud of her commitment to speaking out on the dangers of stealthing and her relentless pursuit of justice for others, in absence of the ability to seek justice for herself. In the 3 years since her assault, we formed a national legislation initiative and worked tirelessly across the U.S. to introduce statutes that specifically specify stealthing as a form of assault. At its core, stealthing is a deep violation of consent, robbing the victim of their right to bodily autonomy. It's a very specific behavior that does not fit neatly within the confines of our existing statutes, and it is time that the verbiage of our laws catch up to the behaviors in our society. Emma shared with you the disturbingly high victimization rates. Chances are very strong that someone you love has been affected by stealthing. One thing that has continued to shock me as we continue on this journey, and as Emma continues to share her story, is the sheer number of people who say, "That happened to me too." As legislators, you have the power to prevent future instances by naming this harm and providing legal recourse for victims when the scope of consent they provide is ignored. Please move SF 662 out of committee and put Minnesota on track to become the next state to recognize stealthing for what it is, sexual assault. Thank you.
Thank you, Ms. Schwartz. Any questions or comments from members of the committee? Senator Verbaeten.
Thank you, Madam Chair. Thank you, Senator Gustafson, for bringing forward the bill. Stealthing is truly a horrible violation, and I had previously carried the bill, so got to dig into some of the research as well. And just wanted to thank you for carrying this on for Senator Dietzick. You've done such an amazing job. I've gotten a lot of emails from advocates, and I'm like, yes, I'm absolutely supportive, just waiting to get put on as a co-author of the bill. But we heard from our testifiers today just how horrible it is. I just wanted to again thank you for truly building like a coalition around this and helping share the stories and help us understand really the extent of the issue. You've done such a great job. Thank you.
Senator Gustafson.
Thank you, Madam Chair, and thank you for those words. You'll also notice, and I'm glad you brought up the coalition, there's a letter of support from sexual assault advocate groups. So it is clearly something that has been in the works for a while. Thank you to Senator Verbaeten for working on this as well, Senator Dietzick, of course. And we hope that this is the year it can move forward and get it across the finish line.
Any other questions or comments from members of the committee? Seeing none, Senator Verbaeten moves that Senate File 662 as amended be recommended to pass and be referred to the Senate floor. All those in favor say aye. Aye. Any opposed say no. The motion passes and the bill, it's on its way to the floor. Thank you, Senator Gustafson.
Thank you, everybody.
Next up will be Senator Koran with Senate File 319. Senator Koran, welcome to the Judiciary Committee. Can you tell us about your bill?
Thank you, Madam Chair. Appreciate it. Just one administrative piece. We do have Michelle Hine here, who was our original testifier. We provided the information on Friday, and then...
We do have her on the witness list.
Excellent. Thank you.
Thank you.
Thank you, Madam Chair. Sad to have to present a bill like this. Senate File 319, what it does is really trying to address the challenges that we have with the fentanyl crisis in this country. What it does, what the basis of the bill does is makes it a felony for knowingly adulterate, alter, substitute a controlled substance drug with fentanyl or knowingly adulterate, alter, or substitute a package, receptacle containing any controlled substance, drug with fentanyl, or another package containing fentanyl. Madam Chair, when we look, there's also a packet of information or a slide deck, I believe, that you have. I'll just cover some of the key components to it. When we look at the strength of fentanyl, and you look at its potency being 50 times stronger than almost any other drug out there, 100 times stronger than many of the drugs out there, 50 times stronger than even heroin, and the addiction is unbelievable. I had, although I'm not a doctor, but I had the privilege, and I've recommended every single member, Madam Chair, you are a medical profession, and you see it every day. If you haven't gone out there to see it on your own, I recommend a ride along with Hennepin County EMS. And it was extraordinary. We've all done them in our areas in rural Minnesota. It's not, there's hardly a comparison. The number of ODs that we went to, we only went to high priority calls and to see what they have to go through. And the only thing I noticed that really different between the EMS ride along was their slow release of Narcan to obtain while they're bagging the person that we picked up, while they're bagging them to get the basic vitals. And they're going through that, and I think their procedures have changed in order to determine if there's hopefully some underlying health condition that would require them to bring the law enforcement officers into the ambulance to involuntarily strap them down to take them in. Versus my ride-alongs with law enforcement have been, they issue Narcan or administer it, and that person gets up, walks away. Same thing happened, at least in my experience, from a OD perspective that we stopped at. They essentially did the vitals, didn't see anything, released them slowly. Then they become extraordinarily violent, ripped out the IVs and everything they had, and then left them. So we essentially dropped every one of them off 10 feet from where they're clinically dead, and that was hard to see. I've got drug and alcohol addiction. 2 of my kids, we fought the battle. Many of the parents who lost children, I'm lucky I didn't lose mine. But I know what it's like every night waiting for that phone call in the middle of the night, knowing that the only thing you can plan for is to prepare for that call, that they didn't make it, but based on some planned use or some unplanned use of drugs. Madam Chair, again, you've got the information in the presentation. I'll just conclude and leave to our testifiers, and Mr. Potts is here to take questions. But there's absolutely legitimate uses for fentanyl, medical uses. Its widespread misuse is having a devastating impact in Minnesota, contributing significantly to the opioid-related deaths. Despite progress, there's been a slight decline in some overdose fatalities, but certainly more harm in the hospitals. Statistics are painting a troubling picture. Our hospital systems are overburdened and growing a number of opioid overdose cases. And the presence of counterfeit pills containing lethal doses of fentanyl, making it even harder to combat the crisis. It's critical that we not only continue to prioritize the education, law enforcement efforts, and the access to life-saving interventions like Narcan, but also increase the consequences for those who adulterate medications and packaging for controlled substances. We need to hold those responsible for manufacturing and distributing dangerous counterfeit drugs. We need to hold them accountable. And we can take this stronger stand in protecting vulnerable individuals and reducing opioid-related harm in our communities. And the last piece I'll leave, Madam Chair, is when you do the ride-along, every OD that they go to and every one of them you talk to, from the EMTs and the engine units to all of those in the EMS units, they haven't seen a drug that hasn't been laced with fentanyl. And it's everywhere they go. And the only variation for me on that night that I rode along was most are fentanyl related and one ketamine. And the ketamine one, they ended up going back 45 minutes later for the same person to do the same administration in Narcan to try and save that person. So with that, Madam Chair, I do have testifier, Michelle Hein, and then Mr. Potts is here for questions.
Thank you, Senator Koran. Ms. Hein, please identify yourself for the record and begin your testimony.
Michelle Hein, M-I-C-H-E-L-E, Hein, H-E-I-N. Thank you and good afternoon, Madam Chair and members of the committee. As I said, my name is Michelle Hine, and I'm the proud mom of Tyler Hine, forever 23, who was taken from us in July of 2020 by a single pill, unbeknownst to him, contained 100% fentanyl. That pill only cost him $20, and he thought he was buying a Percocet. He only bought one, but that's all it took. You see, it had enough fentanyl in it to kill 3 adults. My son didn't have a chance. I am also the co-founder and chair of the Fentanyl Free Communities Foundation, where we educate and raise awareness of the lethal dangers of fentanyl so people in Minnesota know exactly what fentanyl is, how easy it is to access, and how often it's disguised as another drug altogether. We also teach how to avoid it. In high school, Tyler was a 3-sport athlete. He played in the concert orchestra. Only 3 months after high school graduation, he achieved the honor of becoming a United States Marine. He was an avid outdoorsman. He was working toward becoming a yoga instructor and working on his sobriety. He had 4 months in recovery under his belt. Music was a passion of his, and he produced songs for local up-and-coming artists. He was the best son and brother we could have asked for. His love for us was immense, and ours for him. Should have left that out. Tyler accomplished more in 23 and a half years than most people do in 80. His smile and humor lit up every room he walked into. Tyler's life was stolen, and our family is forever broken. People who mix fentanyl into other street drugs need to be held accountable. If fentanyl wasn't in the drug supply in the first place, Tyler might still be here. He might still be battling the opioid use disorder, but he wouldn't be dead at only 23. I have been fighting this epidemic since, and what I've learned is from Mankato to Minneapolis to Mille Lacs. Fentanyl is destroying life with no regard to race, economic status, gender, age, regular drug user, or first-time user. Because our government can't seem to get their arms around this crisis and declare it what it is, a public health emergency, it's left families like ours and so many others to make sure fentanyl is a household word. Most of us have never heard of fentanyl until our kids were dead. Nor did we know that it would ravage our community so badly that we'd all, within a short amount of time, have a whole new set of nonprofits trying to save lives through education, awareness, and changing local and national laws. Tyler died, and we are still losing, 4.5 years ago, and we're still losing 100,000 people a year in the United States to fentanyl and its analogs. Per the Drug Enforcement Administration, fentanyl is the worst drug threat our nation has ever seen. Please, please, help get these people off the streets and fentanyl out of our communities by making it a felony for mixing fentanyl into other substances. This is a deceitful and deadly drug. Thousands of Minnesotans have died from fentanyl overdose and poisoning. Let's not lose any more of our loved ones to this fatal drug. Thank you.
Thank you. And accept our condolences on the loss of Tyler. Any questions or comments?
Madam Chair.
I'm sorry.
I think
Senator
Mr. Potts
Koran.
would like to say a few words.
All right, Chief Potts.
Thank you, Madam Chair, and thank you to the author of the bill here, Senator Koran. I just am here on behalf of the Minnesota Chiefs of Police Association, as well as the Minnesota Sheriff's Association, to voice our support for Senate File 319. I can't really say anything better or probably even any more meaningful than what the last testifier spoke about here, but the sad reality is Tyler's story is way too common in this state and throughout the country. Here in Minnesota, there were 1,800 overdose deaths last year. Over 1,000 of those were as a result of opioids. And according to the DEA, who is doing a lot of education and awareness on this topic, and this plays into Tyler's story, it sounds like, but 6 out of every 10 pills that have some amount of fentanyl in them have a lethal amount of fentanyl in them. And so drug dealers are putting fentanyl into pills to save money on the other ingredients that are in there, but they can't calculate it very well, and 6 out of 10 are lethal. So that means 4 out of 10 may not have a lethal amount, but those pills are what are being sold on the streets throughout this country every day. And I think this bill goes a ways towards helping us kind of combat that in a way that really will be meaningful, creating a separate crime for counterfeiting pills, creating a felony for changing and really misleading folks into thinking they're buying oxycodone, Adderall, Xanax, Percocet, or other pills, but really they're selling them fentanyl. And we really appreciate the author in your bill here today. And again, we support this bill from the Minnesota Chiefs Association as well as the Minnesota Sheriff's Association. Thank you, Madam Chair.
Thank you, Chief Potts. Any questions or comments from members of the committee? Senator Carlson.
Thank you, Madam Chair. Of course, I have a curiosity whether there was investigation, whether there was an arrest and conviction of this person and what they may have been convicted of.
There was,
Ms.
which is
Heen.
very unusual, especially in our state. You don't see that very often. The drug dealer friend that sold Tyler the pill preyed on him for 3 of the 4 months he had been out of recovery, asking him if he wanted to buy, if he wanted to buy, if he wanted to buy. And 12 times Tyler said no in texts, encouraged the man to also get help and please leave me alone, I'm working my recovery. And that 12th time, Tyler bit. Only we and God know why that happened. And it won't matter when I get there, so I won't be asking him, right? Because it's just not gonna matter. But we had a detective and just a great law enforcement community that really went after this guy. And he did plead guilty eventually after 17 hearings 17 months of hearings. And he was convicted of third-degree murder and was sentenced 86 months.
Thank you. Sorry for your loss.
Thank you.
Thank you, Madam Chair.
I will note that stories like this are all too common these days. In my district, I have a constituent who likewise lost a son. I lost a nephew in 2020. He was 20 years old to fentanyl poisoning. I think all of us know somebody or know of somebody who's been touched by this crisis, and it is a crisis, and you're right. This is found in every street drug you can imagine out there. As a paramedic, I do carry fentanyl therapeutically, but it's measured not in grams, not in milligrams, it's measured in micrograms. And that's the amount, very, very small amounts that we use therapeutically for pain management. And the stuff that you find out on the street is thousands of times stronger than that. So thank you, Senator Koran, for bringing this bill forward. Again, Ms. Heen, our condolences to you and your family on the loss of your son. And this bill, Senate File 319, will be laid over. Thanks.
Thank you, Madam Chair and committee. Thank you.
Senator Limmer, you have 3 bills before us today. I'm going to dealer's choice. Which one do you want to tackle first?
I'll go with, Madam Chair, I'd like to start with Senate File 1373.
All right, so 1373. I think that's going to get passed out. It is being distributed.
Which is, are you Matt? I'm Mark. You're Mark, you're Matt, okay. I'll go first, then Matt. But I'm gonna go first. Okay. It's got a Stuart title. Stuart title. Why is that? Mark's in the mortgage business. Oh.
All right, Senator Limmer, Senate File 1373. Could you please give us a description of what your proposal does here, and then we'll take your testimony.
Thank you, Mr. Chair. Senate File 1373 would expand the license suspensions for suspected criminal vehicle homicide or criminal vehicle operation. This bill is based on the tragic events experienced by my constituents, Matt Whalen and Mark Rowe. As you'll hear by their testimony, Matt's wife's grandmother was killed by a driver who was going 90 miles an hour in a 45-mile-per-hour zone. It was the middle of the day, no drugs or alcohol was involved, just the high rate of speed. During the investigation, the family found out that the perpetrator's driver license was not automatically suspended because the statute for suspension in criminal vehicular homicide and/or operation only requires it when there's drugs or alcohol involved, not the reckless ignorance of speed. My bill would close this loophole by requiring automatic suspension for all criminal vehicular homicide or operation cases. It also, just like drugs and alcohol, it also requires law enforcement officer to report to the Commissioner of Public Safety the triggering of a suspension if the law enforcement has probable cause to believe that the criminal vehicular homicide or operation does not wait until the conviction. If later convicted, the license will be revoked, but this would stop them from driving while they wait for trial. As I mentioned before, I have two constituents here, Mr. Matt Whalen and Mark Rowe. I'd like to introduce them to the committee and start with Mr. Mark Rowe.
Thank you, Mr. Rowe. Welcome to the committee. If you would just state your name and give us your testimony.
My name is Mark Rowe. As I said, my name is Mark Rowe, and I'm Sandy Wetterland's son-in-law. On May 6th of 2022, she was over at our home just enjoying a lunch with my wife, her daughter, and her two great-grandkids. She left around 3 o'clock to go visit her husband of nearly 60 years, who was in a care facility right next to where she lived. She was making a turn into her neighborhood off of 101 in Plymouth, and she was hit by a driver with a revoked license who was going actually 97 in a 45. Just to reiterate, his license was revoked at the time this happened. She was hit so hard, her car went through the intersection, went down an embankment, hit the side of a townhome, and broke the inside wall of a townhome. You know, this should have never happened. The driver was already a criminal with numerous convictions for excessive speed and reckless driving. Along with speeding tickets, he was also cited numerous times for no proof of insurance and driving on a suspended license. He should not have been driving. That's it. If he was held accountable for as many prior convictions, Sandy would be here with us today. What makes matters worse in this case is the driver happens to live about 6 doors away from my daughter and son-in-law, Matt. So they have the unique circumstance of watching him continue to disregard for public safety and injustice inflicted on our family. He continues to drive, or had at that time, continued to drive without hesitation. He actually got another speeding ticket about 2 months after killing Sandy. He was driving 88 in a 60 with still a revoked license. Approximately 6 months after he was charged with vehicular criminal homicide, the state gave him his license back so he could drive. When he was finally convicted, he was convicted with 1 year in the workhouse, ended up being 8 months, and his license was suspended for 10 years. Not even a year after that, he was given his driving privileges back to go back and forth to work. I just want to say that, remind everyone that a convicted felon who uses a car or a vehicle as his murder weapon does not drive more safely just because he's driving to work and back and forth to work. Drivers like this don't belong on our roads. Driving is a privilege, not a right. Senseless tragedies like these and the many other incidents that have inflicted harm upon our fellow Minnesotans can be prevented. When it's your family, you really notice how many times these incidents happen. These are in the news, it seems like daily. You're hearing about people driving at high rates of speed, hitting and killing somebody, people driving with revoked license, hitting and killing somebody. They do not belong on, these people do not belong on the roads, and we are putting in your hands to make sure they're not. Let's work together to make our roads safer and hold these people accountable. Thank you.
Thank you, Mr. Rowe. Mr. Whalen.
Good afternoon. Thank you. I'm Matt Whalen. Thank you, Senator. First, to get to where we're at today, I appreciate all the help that our families received. Excuse me. Yeah, it was really tough after the loss of Sandy to witness the individual drive by free, have freedoms yet after killing our grandma. Every day for, it was over a year and probably 4 months before he was sentenced. And still after sentencing, it was another month and a half before his license was actually revoked by the state once he was charged and sentenced. So unfortunately, this situation never had to happen. The state laws should be stricter and get these people off the roads and keep them off the road. This bill here will help people in situations like this in the future to make sure that they're gonna stay not behind the wheel and revoke the license of these criminals that either commit criminal vehicular homicide or criminal vehicular operation. It will add positive things to make sure that things go in the right direction, I believe. From the day after the crash and when we started the process with the Hennepin County Attorney's Office of charging the individual and understanding how the laws and regulations work, we were told that under this law that he was being charged with, he would be charged with criminal vehicular homicide, and it would be 10 years in prison or in a $10,000 fine. Quickly, about 2 weeks after that, we were told that the 10 years in prison would be reduced to 4 years because he was not a convicted felon and didn't have points on his record yet. Understanding that, disappointed in that, deserving justice for grandma, we settled with the 4 years and we were okay with that moving forward. But again, this process took about a year and 4 months to get him finally sentenced. Coming up to the sentencing day, we were told by the county attorney's office that they were going to take a plea deal that was offered by the defendant's attorney. The plea deal was 1 year in the workhouse and 5 years probation. While the individual was in the workhouse, he was still furloughed and still could drive during that time because he still had his license. We did watch him drive by the front of our house a few times, while he was quote unquote in the workhouse. I don't know why they felt that that was unreasonable for killing somebody while this person had a revoked license at the time of the crash, and they felt that 8 months or 1 year was reasonable. This is where it pushed me to get to where I'm at today with this, is to help change the law and hold people accountable. I think it's reasonable to make sure that we are holding everybody accountable and I think this law will start that. And I hope that today's hearing and you guys listening will bring more light to our laws around licenses and people driving without them and suspensions, stuff like that, in that nature. So I appreciate your time, everybody, and thank you very much.
Thank you, sir, and please accept our sorrow for the loss of your family member
Thank you.
under these circumstances. Senator Limmer, did you have anyone else that you wanted to have testify in connection with the bill?
Mr. Chair, I do not know of anyone else that wishes to give testimony on this bill. There might be someone in the audience, but
Okay.
not to my knowledge.
I don't see anyone else standing up to or waving to get my attention on this. I'm going to ask Senate Counsel to step us through the individual provisions in the bill, Senator Limmer.
Mr. Chair, members, it's probably best to consider maybe sections 1 and 3 together. So under section 3, under current law, if a peace officer determines that there's probable cause to believe that a person has violated either the criminal vehicular homicide law or the criminal vehicular operation law, and that it involves drugs or alcohol, they're required to certify this determination and notify the Commissioner of Public Safety. So under section 1, on page 1, when the Commissioner of Public Safety actually gets that notification, then the Commissioner has to suspend the license. And this is basically pending, the criminal determination. Now, both of these sections are specific to, again, only those drug and alcohol offenses within CVO and CVH. So by striking those specific clauses, it expands those two provisions so it would apply to any CVO and any CVH. And then section 2 is under current law when the person, when their license is suspended, and then it's later revoked, they get credit for the time that it was suspended. And that is being stricken for the CVO offenses. You could see that on lines 2.6 to 2.9. So there no longer be that credit.
So then, Mr. Backus, under section 3, then everyone who is, for whom a police officer determines there's probable cause under 609.2113 sub 1 or 609.2114 sub 1, they would all be subject to the certification requirement under the change that's being made here?
Mr. Chair, members, that's correct.
All right, and so that adds in the CVO and CVH cases, is that right?
Mr. Chair, members, the CVO and CVH is already in there, but they're limited to just the clauses that involve impairment by drugs or alcohol. So by striking those clauses, it broadens the probable cause certification to any CVO and any CVH.
So, Mr. Backus, it looks like it's clause 1, right? That would be basically added back in. Is that right?
Mr. Chair, members, I think there are 3 clauses. I'd have to look.
Is there a
think
clause
there's
7, 8?
I believe there's a 7 and
after
8.
that as well?
Mr. Chair, members, yes, it would bring in clause 1 of those crimes, which is when you operate the motor vehicle in a grossly negligent manner. It would bring in clause 7, which is where the driver who causes the accident leaves the scene of the accident in violation of essentially the hit and run law. And it also includes situations where the driver had actual knowledge that a peace officer had previously issued a citation or warning that the motor vehicle was defectively maintained. So it would bring in those 3 clauses for each level of harm.
Mr. Backus, then for that defective maintenance provision, is there any causal connection there between the harm that resulted from the driving behavior and the defective maintenance required? I mean, for example, if they got an equipment violation notification for not having a proper tail light working or something that may not have had anything to do with the driving conduct that resulted in the harm. I'm trying to figure out the scope of this. Mr. Backus?
Mr. Chair, members, each of these crimes are kind of predicated by the conduct. I'm sorry. Yeah, the conduct has to cause that level of harm or death to another as a result of operating the motor vehicle. So there is a causal connection. And then when it comes to that actual clause, I can read it to you. Again, it has to do with the driver having actual knowledge that the peace officer previously issued a citation or warning that the motor vehicle was defectively maintained. But then it goes on to say the driver has had to actually have actual knowledge that remedial action was not taken, and the driver has reason to know that the defect caused a present danger to others, and the injury was caused by the defective maintenance. So I'm sorry, it took me a while to get to that part, but yes, it has to be caused by the defective maintenance.
I see. All right. Before I go any further, are there any questions from members of the committee for either of our testifiers here today? I'm not seeing any, so we'll allow the testifiers then to return to the chairs in the gallery. Thank you for your testimony.
Thank you.
And we'll continue our discussion on the bill. So under existing law, Mr. Backus, then the peace officer makes the probable cause determination that gets certified to DVS that results in a license suspension while the criminal case is pending. Is that current law for alcohol and drug cases?
Mr. Chair, that's correct.
And is that independent of whether there has been a judicial determination of probable cause? Mr. Backus?
Mr. Chair, to my knowledge, it's the only provision on this is what you see before you on page 3, so it's not related to a judicial determination to my knowledge.
And then the peace officer determination, under the CVH law, paragraph 2 is being negligent operation under the influence of alcohol or controlled substances or cannabis or combination. And then you've got paragraphs 3 and 4, which have alcohol concentration. So there's been some sort of a test, breath, blood, or urine, to make that determination. Paragraph 5 then is a negligent operation while under the influence of an intoxicating substance, so that covers intoxicating substances. And then there's any amount of Schedule 1 or 2s, but that would be determined by a blood or urine test, presumably. So you're bringing in gross negligence, leaving the scene, and defective equipment. So I'm just trying to get my arms around this. Senator Limmer, is that what you intend to be the scope of the bill?
Yes, Mr. Chair.
So, I guess let me say this. Whatever happens with this bill, if our two testifiers seem to have left. Oh, didn't expect that. Although I understand how this might be difficult for them to be a part of. But I guess for everyone else who's observing this, suspending a driving privilege, as we all know, does not necessarily stop people from driving. In fact, we know that in this particular case because the person who hit and killed the family member was driving on a suspended license, apparently did not have valid driving privileges. So expanding suspension to cover more circumstances would not necessarily have had any particular benefit in this case. Actually, in this particular case, would not have done anything, presumably, because that person kept driving. And in fact, we know something like 60% or 70% of the people who have suspended licenses drive anyway. And we know that because they have to get to work. They got to feed their families or get to doctor's appointments or do other things, and the likelihood of getting caught, frankly, is a more important deterrent for most people. Unfortunately, we wish everyone would just follow the law when that's the law, but we know in these cases they tend not to be followed as often. And of course, this bill here, as frustrating as I'm sure it was for these individuals' experience with the criminal justice side of the system, this bill does not address anything in connection with how long it takes a case to go to trial, to reach a sentence, whatever the terms of the plea agreement, the involvement of criminal history, sentencing guidelines commissions, all of that are completely independent of the proposal before us here today. And so we're not going to try to remedy that with this bill. So the question standing alone on this bill is whether or not we wish to expand the pre-conviction suspension of driving privileges to the proposed categories based solely upon the probable cause determination by the peace officer, which happens in some of these categories, but not in others of these categories. So I think that puts the question before the committee. I think more finally, if anyone thinks I'm off a bit in my analysis, please pipe up. I'm just trying to make sure we understand exactly what's being presented here for us. And I'm sure counsel would correct me if I stated it wrongly as well, which I would welcome, make sure we understand it. So then the question, with that being the focus of the bill, let's see if there's anyone else in the room that wants to testify in connection with the bill, or if there's any discussion from members of the committee or questions from members of the committee about what the bill does or whether the bill ought to be passed. Pretty quiet committee today. I think we exhausted our conversations on the Senate floor. Or our patience on the Senate floor, perhaps. Senator Kroon.
Thank you, Mr. Chair. And I would just briefly comment that, and this isn't about any technical aspect of the bill, but just in general, that the acknowledgement that people still drive even if their license have been suspended. But from the family's perspective and the victims of crime perspective, there is a difference whether they're driving with the full blessing of our government versus whether they're breaking the law while they're driving. And secondly, even if people don't follow the law, we still have an obligation to set laws that are just and make sense. So I don't think the fact that people routinely drive when their license have been suspended should prohibit us or prevent us from pursuing this bill if it's the right thing to do. Thanks.
Is there any other questions or comments from members of the committee? So when we set up the agenda for today, it was my expectation that the bills were going to be heard so we could have the opportunity for testimony and input and discussion, and then would leave them over for possible inclusion. And also in the event there were any fiscal notes pending to receive the benefit of that. Has there been a fiscal note requested in this bill, Mr. Turner? It certainly could have. I can imagine it could have an impact on DVS and the issuance of suspensions.
Mr. Chairman and members, bills involving suspension or revocation procedure would not have a fiscal impact on DVS.
Okay. All right, well, it's my intent then to, as I had originally planned, to lay the bill over for possible inclusion in an omnibus bill or a public safety package. And so we appreciate the input and the testimony from those who are here today. We haven't heard from DVS on this, so if DVS has any input or anyone else decides they'd like to offer us guidance, there'll be an opportunity for that to happen before we put together a final package. So we are concluded now with Senate File 1373. We will now, Senator Limmer, did you want to, which one of your next two did you want to proceed with?
Mr. Chair, Senate File 1374.
All right, Senate File 1374 will come before the committee. And we will have that. Has it already been distributed? It's coming out right now, members. You'll get your copies at 1374. And Senator Limmer, why don't you go ahead and,
Mr. Chair,
Senator Kroon.
just the last file, we had Senate File number 1373 and this particular bill. My understanding is both of those would need to go to transportation. So if they're going to be included in some sort of omnibus bill out of here, I think we need to take that into account to make sure they get over there to be heard.
Thank you for the reminder, Senator Kroon. I appreciate that. Yeah, it sounds like both committees are laying over some bills that have multiple jurisdictions here, so I'll figure it out with the Transportation Committee and make sure each committee hears it that needs to. All right, Senator Limmer, Senate File 1374. Would you
Thank you,
please
Mr.
give us
Chair.
a description of the bill, and then we'll hear from your testifier as well.
Senate File 1374 would increase penalties for certain violations of driving without a valid license. We have considered this bill before in recent years. It's been modified, and as we've gotten to a more perfect conclusion, somehow the timing just never was quite right to get it over the finish line. Essentially, we identified a gap in the law for people who are habitually a menace on the roads, knowingly continue to drive without a valid license despite their record of bad driving and a disregard for public safety, and then face no greater penalty than a misdemeanor for seriously injuring someone. The bill focuses on the reckless driving behavior of individuals whose licenses have already been revoked due to reckless driving offenses, and not for those whose licenses were revoked for reasons unrelated to driving. So, if you have a driver's license that's been revoked, suspended, or canceled for a specific list of violations or crimes that are related to driving a motor vehicle, one should see the Senate Council summary for which list those citations are listed. And you are in an accident that caused at least substantial bodily harm, or this is your third violation within 10 years, then you would be subject to an enhanced penalty of a gross misdemeanor. I believe this enhanced penalty is appropriate in such situations as those. I have with me today Ms. Sue Vanek, who can share her story, with which was the cause of us considering this proposal.
All right, Ms. Vanek, welcome to the committee.
Thank you, Mr. Chair. My name is Sue Vanek. I'm from Nisswa, Minnesota. I'm here today to kind of share our story and what brought us here today. January 15th, 2015, my daughter Macy and grandchild Sophie were hit head-on by a reckless, unlicensed driver. My daughter today remains completely disabled in a vegetative state. She's going to live in that nursing home for the rest of her life. This once married, productive individual is now divorced and 100% reliant on Social Security disability and Minnesota Medicaid. Our grandchild miraculously recovered after the accident, but it took 20 surgical procedures and 99 days in intensive care. Our entire family was physically, mentally, and financially destroyed by this accident. Essentially, we were handed a life sentence with no chance to return to life pre-accident. The offender received a misdemeanor. The day the offender destroyed our lives was his 9th time being caught driving unlicensed. And as we were prepared for court, I had multiple conversations with our attorney as well as the assistant and county attorney for Crow Wing, and was very frustrated to learn that the most he would be charged was yet another misdemeanor for this event. It was noteworthy that on his criminal record, he has a gross misdemeanor charge for shining a deer. And I was extremely infuriated to learn the consequence for shining a flashlight at a deer was harsher than what he was going to get for putting my daughter in a nursing home for the rest of her life. The judge in our case stated to the offender in the courtroom that he was equally frustrated that current law did not provide him an adequate consequence for the level of destruction he caused that day. Since that tragic day and that accident, our offender has been caught and charged for driving unlicensed 5 more times. That is 14 misdemeanors, and we just keep ticking them off. I'm confused as to why we haven't been imposing harsher consequences on individuals that blatantly and repeatedly are disregarding laws that put others at risk. I have done some substantial studying of other states' laws regarding driving unlicensed and unfortunately came to find that Minnesota is by far one of the weakest. In New Jersey, the offender in our situation would have been charged with a felony and would have had a $5,000 fine and up to 4 years in jail. Driving unlicensed is illegal, and it is no different than driving under the influence of drugs or alcohol. In each scenario, the driver is choosing to operate a vehicle illegally and should not be on the road. It's also noteworthy, and it's come up in discussions, they don't get pulled over for being unlicensed or for being under the influence. Those are items that are discovered when they are caught speeding, swerving, going through intersections, blowing red lights, or in our instance, causing a life-changing accident. These are all reckless acts that can hurt or kill the driver or anyone else that's on that road. So why is driving unlicensed minimized in severity compared to that DUI, DWI? The illegal act is the same. The tragic outcomes to the victims are the same. When I started this project 9 years ago, I wanted to build draft that mirrored DWI law. I was quickly told, and kindly told, that that would not succeed. And the compromise is the bill presented for you today that Senator Limmer so skillfully crafted. I'm pleased to report this session we have bipartisan authors in the House, and we've successfully moved through the first committee. We have had bipartisan authors in the Senate previous years. I'm very hopeful that we can do that same thing this session. And I do greatly appreciate you giving me the opportunity to speak to you today and to respectfully ask for your support of this bill. Thank you.
Thank you, Ms. Vanek. Any questions for Ms. Vanek from members of the committee? Not seeing any, and we're sorry for Senator Pappas.
Mr. Chairman, I'm sorry I've been in and out because I had another bill up, but I just thought that we had enhanced penalties for drunken driving. This is not drunken driving, speeding?
Unlicensed.
Unlicensed. So maybe I'm getting it confused with drunk driving. Thank you.
So, Ms. Vanek, was the conviction for driving after suspension in this case?
Yes.
So the individual had been suspended at the time of the crash?
Yes.
And do you know what that individual was suspended for?
Oh, he has had so many. He's been caught speeding, failure to provide insurance, failure to appear in court for traffic violations. It's like scrolling through Facebook. It never ends when you go through his criminal sheet.
Okay, but was the individual charged with reckless driving, for example? Or with criminal vehicular operation?
It was driving after suspension and careless, reckless driving for our accident.
Okay, and the conviction was for what offense?
Yeah, it was for a misdemeanor, driving
Yeah.
unlicensed and
Yeah.
reckless driving.
Okay, well, that was part of my question. If the conviction was for reckless driving, or if the conviction was for careless driving, or if it was, which are two separate charges, or for driving on a suspended license. Do you remember what the final conviction was for?
The highest charge was misdemeanor. I believe it was for reckless driving too fast for the current road conditions. So they had that, there was speeding, and then the unlicensed charge. I do not remember the chronological order of how they finalized.
I mean, there is a provision in the law, if you're convicted of speeding and you've caused personal injury, where a judge could order a further suspension of driving privileges. But that would be up to the judge. Of course, what you're suggesting here is changing the level of the offense.
Correct.
All right. Thank you for answering my questions. Senator Howe, did you have a question?
Yes, thank you, Mr. Chair. I guess I'm wondering, does this have any, when I look at lines 2.31 and 3.1, with the or and within 10 years, the first two prior convictions under this section, does that include someone under the age of 18?
I don't see any limitation on that. Mr. Backus?
Mr. Chair, that's correct. It doesn't address adults versus kids in that sense.
Senator Howe?
I guess, thank you, Mr. Chair and Mr. Backus. I guess my concern there is holding a juvenile to the same standard as an adult, in my opinion, is my only issue with the bill, I guess. Not saying we should give them a free pass, but I guess I'm looking in my own past, I guess. And from where I finally got my act together, I guess that's where I'm concerned we're not giving someone a little bit of a leeway under the age of 18, but that's my own struggle with the legislation. Other than that, I think it's a good bill.
Thank you. And part of this may be a gap in the statute, and part of this may be an issue of proof that the prosecuting attorney in Ms. Vanek's case had to address. As a CVO statute requires gross negligence if there isn't any other of the complicating factors. And gross negligence is difficult to prove, although if the person was driving in the wrong lane, it seems to me like that might be gross negligence. But I don't know the history of that particular case. It might have been charged and dismissed by a judge for lack of probable cause, or the county attorney may have decided they couldn't prove it and charge it. But it sounds to me like there might already have been a decent charge available in that case. But that's, again, sort of independent of the analysis that we need to bring to the question before us. So am I reading this correctly then, Mr. Backus, that it would become a gross misdemeanor if they were driving while suspended or withdrawn, suspended, revoked, or canceled? And one of two scenarios apply. Either they caused a collision resulting in substantial bodily harm or death, or even if there were no collision, if they had two prior. So a third driving after suspension within 10 years would be a gross misdemeanor? Is that, am I reading that right?
Mr. Chair and members, that's essentially true, except the provision about it being essentially the third within 10 years. There's a list of offenses that could be considered a prior, and that would make it the gross misdemeanor. And Mr. Turner's summary has been distributed, and he has the crimes listed in bullet points. So you could see there, it includes past DWI offenses, past criminal vehicular, homicides or operation, fleeing a peace officer, failing to yield to a pedestrian. There's a number of crimes that would be considered in terms of prior offenses that could potentially enhance the penalty.
And Mr. Backus, are those the provisions which are listed in lines 3.6 to 3.11?
Mr. Chair, that's correct.
So it would matter then what the reason was for the withdrawal as to whether or not it becomes enhanceable. So theoretically, a person without getting into a crash or injuring anyone, but who is suspended, revoked, or canceled for one of the reasons on lines 3.6 to 11, as a prior, oh no, for the reason they were they were under suspension at the time for any of these reasons in the bullet points. Is that right, Mr. Backus?
Mr. Chair and members, that's correct.
All right, so I don't know about other members, but I'd be inclined to kind of read through each of those carefully and decide if I'm comfortable or if any of us, all of us ultimately are comfortable with each of those being a basis for it. Or maybe for some of us, it may not make a difference if it's their third driving after suspension charge, that might be enough. But I think that's the point of analysis. Senator Westrom, did you have a question or comment?
Mr. Chair, thank you. Just, first of all, thank you for your testimony, and sorry for the loss or the injury. Certainly a pretty significant situation of injury and damage. You mentioned right now that there's no way, or people don't get pulled over for driving without a revoked license. Is there any scenario, and Senator Limmer, maybe you know, or if there's, otherwise council maybe can tell us. Mr. Chair, I was just wondering, do we have a situation where if a local officer knows John Doe has a revoked license and sees him pulling down Main Street, can they pull him over? Or do they have to have another traffic violation even though they have knowledge that John Doe is without a license?
Senator Westrom, if the officer knows or has reasonable belief that that individual is driving on a withdrawn license, as long as they can state clearly that they understand that's the person driving the vehicle, then that's a lawful basis. All they need is an articulable suspicion that a crime's being committed to stop them. Sometimes the soft point there is that, you know, they may see a license plate and run the plate, or they may see a vehicle, if they, absent other information, they can assume that the registered owner is driving the vehicle. But if they are in a position where they should have seen who the driver was, or they did, and it didn't necessarily match up with the registered owner, the person that they thought was revoked, and they stopped the vehicle anyway, that would not have been lawful.
That's what?
Would not have been lawful. But if they think they've got the person, they see someone, they know that person's revoked, or they believe that person is revoked, they can stop the vehicle based on that.
Okay. And the reason I asked, Mr. Chair and Senator Limmer, I just wondered if that's an area we should maybe go into more, but it sounds like, I realize in most cases it'd probably be difficult, and the officers may not have a memorized picture of everybody that's has a revoked license, but I just thought of that as the testifier was talking about the situation. To the testifier, how many times had the license been revoked when it happened to your daughter? If
The day of our accident was his 9th time that he'd been caught driving on a suspended or revoked license.
9th time?
Yes.
Okay, so it wasn't the first or second. Was he under the influence at the time, or was it just?
No.
Shouldn't have been on the road?
Shouldn't have been on the road, unlicensed.
Okay. Thank you for coming.
Yes.
Thank you. Any other questions from members of the committee? Senator Pappas.
Mr. Chairman, since there was an injury, he couldn't be charged with criminal vehicle homicide, but isn't there a criminal vehicle operation or assault or something charged that you would have think would have been charged after, 9 violations of the law and a really serious, significant injury to the other driver? I'm kind of I'm confused about kind of the leniency of the charge as well.
Yeah, without knowing more, it's hard to say for
Right.
sure, but Ms. Vanek's saying there wasn't even the charge for the CVO.
Yeah.
So perhaps the charging attorney decided they didn't have basis for a gross negligence
Gross negligence, right.
provision under the criminal
Thank you.
vehicular operation statute. All right, Ms. Vanek, last word, and then we're going to lay this bill
Yeah,
over.
it was in the incident that there were narcotic pain medications found, and so they did do a drug screening, tox screening on him, and it was found that he had prescriptions for a recent surgery, and so there was no level of drug in their system that they could account to the accident. So the driving unlicensed and the reckless driving were the charges, the highest charge they could provide that day.
Okay, that gets a little more complicated too, because having a prescription is not a get-out-of-jail-free card.
Yep.
If you're still under the influence of the prescribed medication, it is a violation of law to be under the influence.
Yeah.
But there is a prescription defense to having the presence of that in your system.
Mr. Chair?
Senator Limmer, last word before we lay it on the table.
Yeah, this bill is slightly different than the previous bill, but it does recognize a public safety threat. There are individuals who call them, for lack of a better term, scofflaws that put the public in serious danger. They don't need to have a drug or an alcohol in their system. They have a long history of ignoring the effect of law. They continue driving in a dangerous manner, and it's been recognized that they've been driving in a dangerous manner. That's why they have a revoked license. And yet, when they do commit serious death or damage to one of our citizens, the existing laws don't seem to quite measure up to the consequence that they make other citizens suffer. I'm hoping by the time we get to the omnibus bill, we will work out our differences and be able to include these in state statute. Thank you, Mr. Chair.
Thank you, Senator Limmer. So Senate File 1374 is laid on the table. Senator Limmer, we have your other bill and Senator Seeberger's bill left on the agenda. Senator Seeberger has a couple of witnesses who came to testify for that. I know that Minnesotans for Open Government has signed up to testify on your bill, Senator Limmer, but with all due respect, Mr. Ealing is here quite frequently, and we have some others who came here to testify on Senator Seeberger's bill that are not regular here at the Capitol. So if it's okay with you, Senator Limmer, I think we'd like to set your bill aside at the moment, and we'll hear Senator Seeberger's bill next, and we'll see how long it takes if we have time to go into yours. Unless Mr. Ealing would like to have clarity right now, we can set it on for a different hearing date if that's easier. My inclination is to reschedule your other bill, Senator Limmer, so that we can give ample time to.
Mr. Chair, I spoke with Mr. Ealing. He can go either way, and I think he's willing to come back at a different time.
Thank you. Then that's what we're going to do, just so we have adequate time for Senator Seeberger's bill. And Mr. Ealing, thank you for understanding. On the Senator Seeberger, we're going to take up Senate File 1329 at this time, increasing penalties for assaulting certain first responders. And I want you to go ahead, and your testifiers are coming forward. That's great. If you can give us a summary of the bill, and then we'll have your testifiers provide their testimony. Thank you.
Thank you, Chair Latz. My testifiers will go into detail for the basis of this bill, but what this bill does is it makes a small change. As the law stands right now, whoever assaults a firefighter or EMS personnel and inflicts demonstrable bodily harm is guilty of a felony for 2 years, imprisonment of not more than 2 years, and a fine of $4,000. What my bill does is it changes it just a little bit, and it imposes a penalty for an assault of a firefighter or EMS worker, not including demonstrable bodily harm. It makes that a gross misdemeanor. And then if you do assault an EMS worker or firefighter and inflict demonstrable harm, it increases the penalty to a fine of not more than $6,000 and imprisonment of not more than 3 years. So we're increasing the penalty for assault with infliction of demonstrable bodily harm, and we're making it a crime to assault we're making it a gross misdemeanor to assault an EMS worker or firefighter in the absence of demonstrable bodily harm. I have with me Shane Hallow, President of the Hennepin County Association of Paramedics and EMTs, and how do you say your name? Mr. Tabakov, a union rep from Hennepin County Association of Paramedic and EMTs. Just like me, they are ambulance drivers, and we're in the business of going out and helping folks. That was a joke. We don't just drive ambulances. We are highly skilled medical clinicians out in the field. But we do face risks daily. And Mr. Hallow came to me after an incident that occurred this past summer that we have video of that I think you'll find, I hope you'll find fairly compelling. I certainly did. At this time, I'd like to turn it over to Mr. Hallow.
Thank you.
Thank you. Just had a little switch over here. Thank you so much, Senator Seeberger. Thank you both for your service and for being patient with us today. I'm glad we're able to hear from you and hear your testimony. But if you want to just start by introducing yourself, your name and title, and then proceed.
Sure. Thank you, Madam Chair and committee members. My name is Shane Hallow. I'm the president of the Hennepin County Association of Paramedics and EMTs. We represent the front line, paramedics, EMTs, and emergency medical dispatchers of Hennepin County EMS. In addition to my union position, I've also served as a full-time 911 paramedic for Hennepin County for the last 11 years. I'm here to express my support for Senate File 1329. As Senator Seeberger stated, I approached her following an incident of an unprovoked attack on 2 of our members on the streets of Minneapolis over the summer. This crew is returning to the ambulance with their equipment when an unknown and uninvolved male approached them, past multiple members of the public, and threw a large piece of concrete at one of their heads. Fortunately, the individual had the concrete thrown at her was able to deflect that piece of concrete, not resulting in a serious injury. I think if that didn't happen, she likely would be more severely injured. This incident is unfortunately not an isolated case, and is just one example of the increasing violence that paramedics and EMTs face daily in the line of duty. Every day, first responders put themselves in harm's way to protect and care for the people of Minnesota.
As paramedics and EMTs, we respond to the worst moments of people's lives, often without the ability to protect ourselves and alone. Yet despite our commitment to public service, we are increasingly facing physical assaults in the line of duty and are routinely subject to violence while simply trying to do our jobs. A recent survey of members highlights the severity of this issue. 78% of our members have been physically assaulted by a patient or bystanders. 74% have been impacted by thrown projectiles, and 92% of our members report that the job has become more dangerous since they started their employment. In 2024, there were nearly 300 events of assaults or threats of violence on Hennepin EMS providers compared to 121 in 2023. These alarming statistics underscore the urgent need for stronger legal protection. The reality is that attacks on first responders are becoming more frequent, more violent, and assaults on paramedics and EMTs are not just an occupational hazard, but they put other people's lives at risk, including the patients that we serve. When an EMS provider is assaulted, it delays care, jeopardizes the safety of the entire scene, and diverts emergency resources away from others who might be in need. I believe that Senate File 1329 recognizes the seriousness of these offenses and appropriately strengthens penalties for those who choose to harm the very people sent to help them or their family members. By doing so, this legislation sends a clear message that violence against first responders will not and should not be tolerated. Stronger legal protection is necessary to deter these assaults, hold those accountable, and ensure that first responders can continue to perform their duties safely and effectively. And while I recognize that some assaults do occur in the context of mental health crises or medical emergencies, I do not believe that this bill is aimed at those situations. Rather, it's about addressing deliberate attacks of violence against EMS providers, firefighters, and other healthcare workers that have been long overlooked and minimized under the current statute. I would request your support on Senate File 1329. Thank you for the opportunity.
Thank you so much for your testimony. Senator Seeberger, did you want to add anything?
Madam Chair, before we lose any more members, I would like to show the video of the event that Mr. Hello has referenced, and I think it kind of paints a picture for you why we're here today before we turn it over to Mr. Tabakov.
Okay, thank you.
Mr. Chair.
Senator Seeberger.
As you can see, the assault came out of nowhere. The person walked past two bystanders, at least two other bystanders, and intentionally targeted EMS workers in the middle of the day. They were clearly EMS workers. They were carrying or pushing their stretcher with a cardiac monitor on it.
Just a minute, we're getting feedback. Eliminate that. Okay.
Pushing their stretcher with a cardiac monitor on it. There's no way they would have been mistaken for law enforcement or anybody other than paramedics as they were heading to the ambulance. The video that you saw was recorded from the exterior of the ambulance. You can't mistake an ambulance for anything other than an ambulance. So again, these workers were incredibly fortunate. And this is the kind of thing that we face every day. Before I get to Mr. Tabakov, I want to stress that this came to me because this person was caught, he was arrested, he was prosecuted, and at sentencing, the judge indicated that they were frustrated that they couldn't hold them accountable for a longer sentence because of the way the law was written. That is the context and the underlying reason why this bill came to me. We're not just here trying to increase penalties with no basis for it. There's a very real basis for it. And with that, Mr. Chair, I'd like to turn it over to Mr. Tabakov.
Hello. Mr. Tabakov.
My name is Ivo Tabakov, common spelling. IVOTABAKOV is my last name. I'm a paramedic for
Hennepin EMS, and I have been working there for almost 12 years. I stand before you today not just as a paramedic, but as someone who has witnessed and experienced the violence against paramedics, against those that dedicate their lives to save others. Almost 2 years ago, on June 10th of 2023, I was working as a paramedic. We received a 911 call for a individual possibly having a stroke in downtown Minneapolis. When we arrived on scene, we found a patient who was acting erratically, possibly under the influence. The police responded also. It was a good thing they did. They found a bunch of knives this individual had in his backpack, and they put him in the outside compartment of our ambulance. We started transporting a few blocks after. I was in the back with this patient. He started taking his seatbelts off and tried to punch me. I yelled for my partner, who rushed back to help me, and both of us were trying to hold this person's arms so he cannot punch us in the face. We activated our emergency buttons on our radios to summon police, but still took probably 2 minutes for them to show up. The whole time I was thinking we're lucky that we left that backpack with knives in the outside compartment and the patient couldn't access that. But that good feeling was short-lived. The next thing I remember was I was on the floor of the ambulance. My head was spinning and I couldn't think clearly. What had happened was the patient kicked me with enough force to snap my head back and hit the back bench support that was behind me. At the hospital, I was diagnosed with a severe concussion. The doctor told me that I can't work until I see a traumatic brain injury specialist, and also to be careful because another head injury the next few weeks could be fatal. All of a sudden, the job that I really liked and the career I worked really hard for was in jeopardy. I spent over 6 months off of work. I had to attend numerous neurology appointments, therapy, and tests. Almost 2 years later, I still see a TBI psychologist to help with the trauma from that incident. I have nightmares, flashbacks, especially in the back of the ambulance when I have a violent or aggressive patient. The individual was charged, but those charges were dropped by the prosecutor and nothing ever happened. And this is not just my story. This is the story of countless paramedics and first responders who go do their job and don't bring weapons to the job. They bring compassion. We try to heal. We don't try to hurt anyone. And we're being attacked, injured, and sometimes even killed. I ask you and urge you to protect us, to protect those that protect you, because I was lucky I could walk away, but somebody else may not be as lucky. Thank you.
Thank you, Mr. Tabikoff. Any questions from members of the committee for either of the testifiers? Not seeing any. Anyone else in the room want to testify in connection with the bill? Anyone left in the room here? That's all right, any discussion? Members, the intention is to lay the bill over for possible inclusion. I think we're waiting on a fiscal note as well for this one. Oh, we're not. Oh, this is one without.
Mr. Chair,
Senator Seeberger.
it's my understanding we do have a fiscal note. There's no cost attached. So my request would be that we vote on this bill today and move it to the floor rather than request it to be possibly included. As you can see, these assaults happen every day. I've been in that same situation. These things, they happen just as fast and as unpredictably as you saw in that video. I know we've talked about this before. I know this bill has come before this committee in various different forms, but I think that now is the time to act, and I'd love to see this thing move forward and move to the floor for a full vote.
Thank you, Senator Seeberger. It was my intent when we scheduled this bill for a hearing, along with the other penalty enhancement bills, that we would hear them and we'd lay them over. Whether at some point they proceed on their own or as part of a package is yet to be determined. But I appreciate your sense of urgency in wanting to move this forward. But at this time, we'll just take further conversation, if any, and then we'll lay it over. Senator Koran.
Thank you, Mr. Chair. Real briefly, and this isn't that, I don't know if this is a big deal or not, but a lot of the fourth degree assault carve-outs or special situations that we have, including the one from Senator Gustafson earlier today, had a feces and urine component, and seems like for this one, be more likely that would happen here than it would for a referee or ump, and I don't know if that's something you thought about and purposely didn't include, or if that's something you might want to add before it goes into an omnibus bill, just to keep it consistent with some of the other ones in the statute.
Senator Seeberger, any response?
Thank you, Mr. Chair. Senator Coercion, yes. And in fact, that is something that clinicians on the street face daily. The problem is that now we get into the murky territory of, is this criminal or is this somebody with a mental health concern? Is it intentional? Is it an offshoot of the condition that we're there to address? And so I know in the past that has been a component of this enhancement bill before, when it's been brought before the committee, and mental health advocates have cautioned against proceeding that way. I elected to not pursue that particular piece of behavior just out of those concerns, and to hopefully, fingers crossed, see this thing finally get to the floor and finally get passed. So that was my thinking. I'd love to see it. I don't want to tank the whole bill by including that piece, if that answers your question.
Senator Kroon.
Thank you, Mr. Chair. Yeah, I just wanted to make sure that you had thought about it, if there was a reason it wasn't in there. I don't have a particular preference one way or the other, but that what you said makes sense. Thanks.
Any other questions or conversations? Senator Pappas.
Madam Chair, Mr. Chairman, I kept calling the president, Madam President. Just to look back at 1374, evidently this actually did pass the Senate floor in 2018, and it does need to go to transportation. So I just wanted to make that note. I don't know if you mentioned that before.
Well, 1374.
1374, not this one, 1374. I just was thinking about this one going on its own, and then I was thinking about 1374 as well. So I just wanted to remind the chair, the staff probably is already very much aware of this, that it could always go to transportation and come back if you wanted it as part of a package. But it does need to go to transportation, apparently.
Thank you, Senator Pappas. Any other discussion? Seeing none, Senate File 1329 is laid on the table. Members, we will have our next committee hearing on Wednesday, March 5th at 12:30 in this room. That's it. We're adjourned. Thank you.